Well, lot of people come to our office or call us in panic mode to get them anticipatory bail for reasons like wife threatened to file or already filed false dowry and domestic violence case on him and his family, or girlfriend threatened to file false rape case on false promise of marriage, or they got call from police station, or they got summons from court for bounced check. One thing is common among all these, is not understanding the basic law and bails. Hope this video will clarify some doubts of anyone who is interested, and also people who approach us in panic and urgent need, so they can watch these videos to understand the things, which we explain to each and every person again and again. You can watch them while waiting for appointment, and this will save your or your advocate's time. This will also help you to get our quick appointment, and more time can be given by us to analyze the evidence you will bring to help you better. Hopefully after this video, people will be more calm and will be in better frame of mind to ask proper and better questions. It's seen that very often, frivolous and fake false cases are filed against other people due to enmity, revenge, monetary benefit, blackmailing, self-protection, etc. In our society, the arrest by police leads to harming of reputation, and also lot of money and time of people is lost by these false cases. Hence, to avoid all this, if any person has reasons to believe, for any reasons like mentioned earlier, that a false case is filed, and they may be arrested immediately or in recent future for a non-bailable offense. Remember, non-bailable offenses only, then in that case they can apply for anticipatory bail in the Sessions Court, and then High Court or directly High Court before they get arrested. Anticipatory bail protection is only for a limited period. After charge sheet is filed, then you get regular bail, because many times based on evidence, the charge sheet changes by removing or adding sections in charge sheet. If anticipatory bail is time-bound, then its period can be extended by making an application to the High Court. Anticipatory bail is better than interim bail, because it is permanent. It is definitely better than regular bail, because you not have to spend even a single day in custody with anticipatory bail. Anticipatory bail is very common in 498A, which are filed by women. Anticipatory bail means you have anticipation of arrest. It is not anticipation of complaint. Threatening of filing case is not a crime, threatening of filing false case is only a crime. So wordings are very important. Only when a complaint or FIR is filed against you, or if the police have called, given notice, or come to arrest on the basis of the FIR. Complaint or FIR is not required if you are some big shot having very big status in society and reputation to defend. Anticipatory bail is applied after a complaint is filed for non-bailable offense. Anticipatory bail is only before arrest under Section 438 CrPC. After arrest, apply for regular bail under Section 437 CrPC. In a non-bailable offense, bail is a matter of discretion of court. Anticipatory bail is only for particular complaint or FIR, and it is not blanket bail. If there are more than one complaints or FIR, then anticipatory bail is required in all those cases. If you take anticipatory bail only for one FIR, then you can get arrested in another FIR. Do not waste time, and thus make case strong for rejection of anticipatory bail.
What is procedure for anticipatory bail?
First of all, anticipatory bail is not instant like exactly what is portrayed in movies and TV. Anticipatory bail needs to be applied and take days. Your advocate will guide you on precautions and proper way to manage it. When you need anticipatory bail, then immediately call your advocate and give him authority to represent you. Anticipatory bail application will be made. A copy of FIR is also required. You have to narrate your defense to your lawyer and provide documents to make proper application. You have to sign on accompanying affidavit. Anticipatory bail application will be filed in court. In court, judge will ask public prosecutor for objections and records as per process. Public prosecutor will ask for time to study the complaint or FIR and CD. This is where your advocate have to manage. Your advocates and public prosecutor will make their arguments, and based on them, judge will reject or grant bail with conditions. This is the most important step. When granted, this anticipatory bail is final until it is cancelled by application by opposite party.
Which factors can influence bail?
Severity, gravity of the offense, your past record of criminal activities, your past record of misuse of earlier bails, your past record of conviction, possibility of running away or absconding, complainant motive, medical condition, if any, your status in society, like employment, financial condition, family ties and relationships. If you are sole breadwinner, the following conditions will or might be imposed by judge as per court discretion. You make yourself available for interrogation by a police officer when required. You should not, directly or indirectly induce, threaten or promise any person. You should not leave India or state or city without the prior permission of the court. Other conditions which are similar to that of regular bail.
Ruling of 5-judge bench of the Supreme Court.
The 5-judge bench overrules several judgments, putting restrictive conditions for such bail. Pre-arrest bail means anticipatory bail can be granted in all offences, except in cases of rape and gang rape with minor, as mentioned under Section 438 of CrPC. To continue after filing charge sheet, and even till the end of trial. No inflexible time frame on its continuance. Can be moved, even prior to registration of FIR. Not to end, when the accused is summoned by the court. Court can make it conditional, in view of the gravity of the offense. Investigating agency means police in most cases can seek cancellation of bail on non-cooperation, evasion, intimidation, or inducement to witnesses. 5 judges Supreme Court bench, on duration of anticipatory bail. The life of an anticipatory bail order does not normally end at the time and stage when the accused is summoned by the court, or when charges are framed, but it can continue till the end of the trial. A denial of bail amounts to deprivation of personal liberty, which is a fundamental right under Article 21 of the Constitution. Thus, the court should lean against the imposition of unnecessary restrictions on the scope of Section 438. Parliament has not thought it appropriate to curtail the power or discretion of the courts in granting pre-arrest or anticipatory bail, especially regarding the duration, or till charge sheet is filed, or in serious crimes. Therefore, it would not be in the larger interests of society if the court, by judicial interpretation, limits the exercise of that power. Grant of anticipatory bail. The court held that anticipatory bail can be filed even before the registration of FIR, as long as there is reasonable basis for apprehension of arrest and clarity of facts. An application for anticipatory bail should be based on concrete facts, and not vague or general allegations. The application should also contain bare essential facts relating to the offense and why the applicant reasonably apprehends arrest. The grant of protection should not be blanket but confined to specific offense or incident, for which relief from arrest is sought. It is open for the police to move court for arrest of the accused, if there is any violation of bail conditions. Conditions on anticipatory bail. It is open for a court to impose appropriate conditions for grant of anticipatory bail, if the specific facts or the features of the offense involved demands it. Restrictions or conditions can be imposed only on a case-to-case basis. Courts have to consider the nature of the offense, the role of the person, the likelihood of his influencing the course of investigation or tampering of evidence, including intimidating witnesses and fleeing justice. It is essential for the court to evaluate the threat or apprehension, its gravity or seriousness, and the appropriateness of any condition that may have to be imposed. Special or other restrictive conditions may be imposed if the case or cases warrant, but should not be imposed in a routine manner in all cases. Hope this video will be helpful to someone.